Alex here with part 2 of the My Docket series on child custody and visitation. As with my previous video, I'd like to direct people to part 0 of the series. That is the video that goes into all the disclaimers and also lets people know where I'm at in my case right now, which is important because I didn't want people to think I made this series to get people to feel sorry for me or to gain allies or support or anything like that. My case is completely and totally closed. My ex's parental rights have been terminated. It's done. The purpose of this series is to help people by giving them an example of what I have already gone through given my 8-year-long high conflict child custody ordeal, representing myself most of the way through it, with my ex having an attorney most of the way through it. Now, in my previous video, and if you haven't seen that one, you should watch that one too, I filed the petition to establish child custody and visitation. My ex was served on September 3rd, and pause right there because guess what happened? On September 5th, she filed a petition for order of protection against domestic violence. This is what many people call a restraining order. In Nevada, we call them orders of protection against domestic violence, but that's what it is. She filed it on September 5th, and having gone through it and read it, I am mostly certain that she went and had this thing filled out upon getting advice of an attorney. I looked over the documents, and none of these documents show that her attorney has made an appearance at this point, but I have a strong suspicion that her attorney did make an appearance at her first hearing for that protective order, for the temporary one. I'm not sure. I haven't even seen the video on that yet, believe it or not. After all these years, I have not seen the video as to what went on for that first hearing, the one where my ex was given the temporary protective order. And in fact, I looked through these documents. There's only 2 of them. And I realized I haven't seen either of these. This is the petition that she filed against me, and it wasn't served on me. What the sheriff served on me was just the order. It was the temporary order for protection against domestic violence. And that one I'm going to cover in a separate video because we're not there yet. This video, I'm just going to cover the petition that she filed. And also, as I mentioned in part 0 of the series, I will go ahead and lump in what I call housekeeping papers, ancillary papers. So you'll see like my proof of service from my other case that I filed. But for the most part, what I'm going to cover in this video is my ex's response to having been sued for child custody and visitation. And this response is very common. I'm sure many people have gone through it. And that response is for your ex to sue you and try to get a, as many people say, restraining order put on you. In Nevada, that's not the formal way that the court refers to it. They refer to it as getting an order for protection against domestic violence issued against you, but I just couldn't help but say that because it's just one of those things that more often than not happens. At least it did in the old days. It doesn't seem that it happens as much now as it used to, and I think it's because this whole tactic of trying to get a restraining order to get a leg up in a child custody case is starting to backfire more and more, and it seems like attorneys are starting to realize it, and they're no longer advising their clients to just go out and get a restraining order because then you can use that to win your child custody case. That used to be what happened, at least according to what everyone has heard from the old days, but nowadays it doesn't seem to be as common of a tactic. So I'm going to go ahead and mention that what my ex did with this one piece of paper had a profound impact, not only in her case, our case, but also for all of the parents in the state of Nevada. Because this piece of paper, or pieces of paper, it was a whole petition, this is what led to me being published in the Supreme Court of Nevada. This triggered a chain reaction where she doubled down later on and doubled down again, the second time being the time that she went and got what they call a fictitious address from the confidential address program for victims of domestic violence. She used this petition and the temporary order of protection to get that fictitious address, which led to me suing the government, the Secretary of State, under various different statutes, and bringing it to the attention of the Supreme Court of Nevada, whereby they responded by publishing an opinion that would forever change the way that the domestic violence program would work for people in the future. This one little lie had massive consequences for not just our case, her case, but also for all of the other actual victims of domestic violence in the state. Because of her, anyone can now come forward. You could say because of me too. From the side of the person who is wrongfully accused, you could say because of me. From the side of the actual victim of domestic violence, you could say because of her. Because, I mean, she's the one that messed that up for them, and I'm the one that created this doorway for other falsely accused people like me. Anyway, what I was trying to say is because of her, any person now can come forward and file a petition for writ of mandamus under the case that I was published on, Falcone v. Secretary of State, and force their ex to go back into court and prove that they were actual victims of domestic violence with clear and convincing evidence. Otherwise, you guessed it, their fictitious address gets canceled. And even there may be situations where they don't cancel it, but what they do is they order the so-called victim to give their address, which they're trying to keep secret, to the other parent of the child. So I just really wanted to spend some time and focus on the reality as to how much of an impact this one misstep that she took had on the remainder of her case and on the entire citizenry of the state of Nevada. And I wouldn't be surprised if other states of the Union start to extend Falcone v. Secretary of State into their case law as well. Same with, this actually wasn't the first state to do this. My case is based off of a New Jersey case called Sakharov v. Sakharov. And what happened in New Jersey was very similar to what happened to me in Nevada, with the exception that in New Jersey, the issue as to being able to hide or conceal yourself because you're afraid of domestic violence occurred prior to the entry of the decree of divorce in that case, whereas in my case, all of this nonsense came up. Well, obviously she filed it before the judgment was entered in my child custody case, but the real crazy stuff, which was the stuff associated with the confidential address program for victims of domestic violence, that part didn't come up until after the judgment was entered. And so the Supreme Court of Nevada had to go ahead and create an additional mechanism for somebody like me, for a parent like me, to use to challenge the Secretary of State's confidential address program. So that all being said, we can go forward and look at what my ex has filed. So my ex was served on September 3rd, 2008 with the petition to establish child custody and visitation. She turned around 2 days later on September 5th, 2008, went back to that same exact courthouse that I had gone to a few times by then, and filed against me an application for temporary order for protection against domestic violence. So this is the document that I'm going to be going through in this video, along with the personal case information sheet that she had to file to institute this case against me. That's just one of those housekeeping papers that I'm just going to cover on top of the main topic of this video, which is the application for order of protection against domestic violence itself. That being said, I do want to mention that my mindset at the time of being served with this application was really bad. I was panicked. At the time, I had never imagined that she would do this, because during our relationship, even when times were getting bad, I was always the type that would want to get out of the situation. As it got more intense, as the argument got out of control, as the discussions went round and round and made no sense and quite frankly devolved into devaluation, I would do everything I could to get out of the situation. My impulse was not to retaliate or get revenge or get violent. My instinct was to leave. And most times that wasn't a problem, but there were 3 or 4 times where she wouldn't let me leave. she'd grab onto me, grapple me. One of the most common things she'd do is take my clothes and stuff, so I'd try to put them on. She'd take my shoes and hide them, take my pants, hide them, take shirt, hide it. Just make it as difficult as possible. She knows, you know, I'm not going to leave out the door naked, and I'm sure this is not something that just happened in my case. This is probably something that many other people have gone through too. And to have been the type of person who has done everything in their power to not commit domestic violence, to have that attitude for so long and then still be accused of it, it's enough to kind of cause a mini heart attack in a person, especially someone who's never been to court, somebody who's never been accused of something like that. So it was really alarming. It shocked me. It freaked me out. And I didn't know what to do. And later on in the series, I'm going to get to the point where there's a hearing video where you can see how this particular hearing went. And I'll go into more of how I came to terms with what was happening to me, how I came to realize that she was using this application to get a leg up in the child custody dispute, to get revenge on me for having her served with the petition to establish child custody and visitation. And all those details I'm going to discuss later on as we progress in this series. But for now, let's just look at this document. First thing I wanted to mention is it is a self-help form. I already talked a lot about these self-help forms, pros and cons and all of that in my previous video, so I won't go into that again. Just like with the previous video, we've got the code number in the top left, file stamp top right. In this case, because she sued me, she is the applicant in this case, and I am the adverse party. These titles, I don't know where they come from. I don't know. I mean, some of these papers that are filed, some of these pleadings, they have a plaintiff and a defendant. Others have a petitioner and a respondent. Others have an applicant and an adverse party. Others have the obligor and the obligee. And I'm not sure why they use these terms. And if anyone here is curious about that, or if anyone has any insight as to that, definitely post in the comments below to let me and the other viewers know. Case number, as you can see here, we have a different case number. This is because in Nevada, the application for temporary order for protection against domestic violence is a separate type of proceeding. It's a proceeding that was created by the legislature in Nevada. They basically enacted a series of statutes that defines the proceeding and how it works and what the court's supposed to consider and what the court can do. And so for those reasons, when somebody institutes this particular proceeding, it gets a brand new case number, a completely and total and separate case number. It does not get lumped into my child custody and visitation action that I filed previously. Though I have heard of decisions in these cases being deferred to judges in the actual divorce action or the actual child custody action that was filed. So I'm not sure why it falls under its own case number and the papers and pleadings are filed separately, but for whatever reason, in this case, this is how it happened. I would also like to know if anyone has any insight as to that. Some of these technical details as to why they have separate cases and why they consolidate some cases and why domestic masters will rule on one but a judge can rule on another. Some of these little questions and these little technical details are more important than they might seem, and unfortunately I don't have all the answers to all of them, and this is one of those examples of a situation where I don't have the answer to it. So she fills out most of the boilerplate blank, dates and times truthfully, and as with my previous video, I'm not going to focus on every single line in this pleading. What I'm going to do is jump to the parts that kind of jump out at me, the areas that I want to highlight to the viewers. So as you can see, it looks like we were together for 2 years. That sounds about right, especially at the point that this was filed. She admits the truth mostly. So far, we see she's admitting that we lived together, that we didn't live together anymore, which is true. Here's where she keeps her address confidential. At this point, she hasn't signed up for the confidential address program. That occurs later on, but at this point, she has already indicated her desire to stay at a secret location because I'm such a dangerous person. And this is a stance that she takes for the entire 8 years. This is a stance that she will not let go of, it really was what ruined her in the end. And like I mentioned earlier, I don't want to get too much into the future, but this refusal to disclose where she lived was ultimately what led to the termination of parental rights. It really was. So this is old address, otherwise I would redact it. Way old, like ancient history. She keeps her employment confidential, which is silly because I know where she worked at the time. She worked at the VA hospital. This is what I was talking about. I think I've talked about this in a few of my videos. I worked at Circuit City when I was still in college. And this is, of course, Circuit City is now bankrupt. So here, she does admit that he's my son. I've been asked a few times by viewers why she didn't just say he wasn't mine. I guess a lot of people will try this tactic. I'm not sure why she didn't. I think that it's kind of one of those things where some high conflict exes will say it's not your child to just try to get rid of you or make you jump through a few more hoops. Other high conflict exes won't do that because in their mind they're going to win and they want to get a child support award. And if they say you're not the father and you don't stick around, they're not going to get the child support award. So, I mean, it's not that simple as to why some of the high conflict exes will say, no, that's not your kid, and others won't say that. So here she admits that there's a custody action open. Here's a checkbox for CPS having been called in the past 5 years. What happened was she attempted suicide, and so when I called the police and they sent the ambulance, all that, and they took her to the mental institute for a 72-hour hold at it's a mental hospital in Reno. CPS came by at the time. I don't know if they came. Yeah, they came by the day after. So by then she'd already been removed from the home, and she was at the mental health hospital. They came by the day after because they were concerned. I guess it's automatic protocol when a mother or a father of a child tries to kill themselves. And they came by, and I believe they opened a case very briefly because they only came by one more time after that when she was released, and they never came back again. There was resistance to CPS. At this time, I wasn't really assertive. I mean, I wasn't even close to assertive. I was so far from that. I was what they call codependent back in the day. Now they're starting to call it self-love deficit disorder. She was the assertive one in the relationship, and she refused to allow CPS to enter the home. I do remember the police coming because CPS called them, and she allowed, and I can't say we because I really didn't have a say in any of this when we were together. I have to say she allowed the police to come in and inspect the home and inspect the child. And the police went back out and told CPS everything was fine, and we never heard from them again. They closed the case. I do recall them being really angry, though, that they couldn't themselves conduct the investigation, that they were refused access to the home. I recall her mentioning that this was an issue when she was growing up with her family, but I don't know any of the details. It was something with either it happened to them because they were homeschooled, or it was something that in their homeschooling community they had drilled into them. Something like that was going on. I can't remember the details. So here she says believes she's going to be a victim. I love how she says the child's in danger of being a victim. I have to mention a couple things here. If I really didn't like her, all I had to do was not call the police when she tried to kill herself and just let her die. That would have been the easiest way to get rid of her. So I could have just done nothing, and that would have solved the problem. I was the one that picked up the phone and called the police, and then the ambulance came, and then they took her to the hospital, and they fixed her up, and then, sent her to the mental health, hospital. All I had to do was nothing. If I really had a problem with her, if I really wanted to see her go away, I could have just done nothing. Nothing at all. That would have solved that would have solved the problem that she alleges later on in this petition that I wanted solved, which was to get rid of her. But just wanted to mention that, like, this part here where she thinks she's going to be a victim of domestic violence committed by the adverse party, honestly, she should reasonably believe that she's going to be a victim of domestic violence committed to her by herself, not by anyone else. I mean, that was just this CPS incident here in the police report, which comes up later, which I'll go into more later, was really one of the points that my family judge used to sort of expose the contradiction. Because later on it does come up that she, half-heartedly alleges that I'm a dangerous person, and the judge he does kind of say some things that are a little rude, but he does, I can recall, and again, I don't want to jump too much into the future because we're going to eventually get to these points in the series, but I can recall him really concerned with her allegations that I was violent when she, tried to hurt herself. The second thing here, my children have been or are in danger of being a victim, is also, it's just, it's almost laughable, because I was taking care of him while she was gone in the mental health hospital. And so, I mean, he couldn't be that much in danger, because, at least not for me, because I was the one taking care of him while she was gone. So here we go into the facts which support the application. Now, I'm going to actually spend a little bit of time on this, because number one, I think a lot of people will be able to relate to it. A lot of the people who've been falsely accused anyway. And number two, I want to show people a technique that my ex uses, that a lot of high conflict, emotionally immature people, a lot of personality disordered people will use to convince people that they're telling the truth. And what they do is they will sandwich a lie between two truths. It's not literally in the sense that they'll tell the truth then lie then tell the truth again. It's not literal like that, but the point is they will say things that are true or at least plausible, and somewhere in that combination of allegations they will slip the lie that they need to slip in to get the relief that they're requesting. The point is they need a certain conclusion to be reached, and so rather than think logically and apply all of the facts to determine whether or not those facts lead to a conclusion, they go through this backwards process. They will decide this is the conclusion that I need, and then they will try to build or form the facts up in a certain way so that that conclusion is reached. I call it reverse logic. Okay, so here she says she's requesting a TPO because she's scared that I'm going to find out where she lives and shoot her. This is absolutely insane. It's completely, totally the furthest thing away from what I have ever thought to do to anyone. Take the child by force or break into the house. Again, I didn't really have to shoot somebody who wanted to kill themselves. So this is beyond ridiculous. He has made statements about getting a gun and a concealed weapons permit. Now this is true, but this wasn't after we broke up. If you read this carefully, you can see it says he has made statements about getting a gun and a concealed permit. This was an innocuous statement, probably during the time when we were both really big on Ron Paul's campaign. So what she did was take a statement out of just an ordinary time when we were doing just fine together, and she inserts it in this application. And any judge who reads this might think, well, he made those statements after getting split up to scare her. So he decided to tell her, now that we're broken up, I'm going to go get a concealed weapons permit and buy a gun. The way that this sentence is added in here, it allows her to make a false allegation, yet at the same time, it allows her to back out of it later on if she's called out. Because if the judge says, man, you're a liar, he didn't say that he was going to get a gun and shoot you, she could, if she was later on, if she was caught and she had to admit to it, she could say, well, if you read my statement carefully, it doesn't say that he was going to get the concealed permit so that he can buy it and to kill me. He just says, I just put down that he said he was going to get a concealed weapons permit. And of course, I mean, it sounds ridiculous to a normal person because there's other parts where she alleges that I'm going to shoot her. But in the way that they think, to them, it's like a way that they can back out later. To them, it's like, it's a way to make a false accusation whilst at the same time having a path of retreat. Like I said, to an ordinary person, it's still going to sound like a ridiculous excuse. But in their head, this was the best way to lie without having themselves trapped, without leaving themselves an out. So she says further, I'm afraid he has by now. So she's saying she's afraid that I have a gun by now. I didn't get a gun until after this. So I didn't, she may say she's afraid of it, but I didn't have one. In August 2008, he filed for custody, so she admits that. Soon after leaving us 5 months before. This is another common way. This is a common way of characterizing an ex as a parent who's abandoning the child. It's more common that people accuse a husband or a father of abandoning the child. The thing is, it's not that the person has abandoned the child, it's that the person has abandoned the relationship. They still want to be there for the child. And oftentimes, the parent who feels betrayed or left behind refuses to allow contact with the child as a punishment, as a way of getting revenge. Later on, they come back to court and they don't say to the court, Your Honor, my ex left me and I decided he couldn't see the child because that hurt my feelings. What they'll say is, Your Honor, my ex left me and abandoned the child. And this is something that you see over and over again all the time in these types of high conflict cases. If you leave the relationship, you are abandoning the child. And it's only because that parent will refuse to allow contact. He showed up at my work with a friend to serve me on the 28th and 29th. I love how she puts serve in quotation marks. Like it's something I invented out of thin air. No, that's something that's defined in the Nevada Rules of Civil Procedure. So if she has a problem with being served, she needs to have a problem with the Nevada Rules of Civil Procedure. At midnight, now here, this is also misleading. This makes it seem like I specifically wanted to find her at midnight at her job and scare her. What this leaves out is all of the previous emails and text messages mentioning that I had instituted child custody proceedings and that I needed to have her served. She could have responded, okay, send the process server to my house, don't come, and please come at this time when I'll have friends here or something like that. If she was scared, she could have said, okay, I'm going to have some friends here on this day and time, please come and serve me on that day. Or she could have said, don't serve me at my work because I don't want to be embarrassed in front of my coworkers. I will just meet the process server, at the grocery store or like a Wendy's or something like that. What she did was she responded and said, I don't know what you're talking about. I don't know what a lawsuit is. And then I would send like the petition in an attachment and she would say, she wouldn't even respond. It was I've talked about this in the previous video. She was playing dumb. And so the first time I tried to serve her at her work because I didn't know where she lived was during daytime hours. Went to her work, went to HR, and they wouldn't come down. They wouldn't send her down. They said, she doesn't want to come down. There's nothing you can do. We can't force her to come down and get served. Blah, blah, blah. I do believe there was an attempt to get her on her way to work, which would have been at 3:30 p.m. instead of at midnight, but that didn't work either. Then there was the second or third or fourth attempt at her work, I can't remember which, where the midnight was tried. And she sent the VA police down and they said to come back during business hours. So then, as I mentioned in my previous video, after that, we came back during business hours again. And that was the time that HR was kind of shocked to see that she still hadn't been served. And that was the time that they got pissed off and they said, we're going to force her to come down and take these papers. Once they realized she was using her workplace as a hide-and-go-seek, a place to play hide-and-seek, they got sick of it and forced her to come down. And she did. Once HR ordered her to go down and take the papers, she did come down and take the papers. But it's just, one of the examples here is if you read this sentence, a personality disordered X or an emotionally immature X, they will make statements that are true and they will leave out important facts to make it seem as though you were trying to do a certain thing. So somebody here who's ignorant as to high conflict child custody would think that I specifically decided to show up at her work to embarrass her and I specifically chose midnight to scare her. That's what it sounds like to a person who doesn't know what's going on. In reality, that was a last resort because there was no other way to serve her. So let's continue here. The 27th of May, after he called at 1:51 a.m. to talk to the baby, he got angry and said, you are in between me and my son, and if I have to, I will take you out. Now, this is something that I remember being brought up at the hearing. This is the bald-faced lie. There is no way on earth I called her at nearly 2 a.m. to talk to an infant child who would for sure be asleep. This is the one lie that I wish I had known was in writing, because when I first heard this, I heard it in court. I didn't know that this was in a paper. And so what I would have done was, well, maybe I wouldn't have done it because I really didn't know how to represent myself at the time. What I should have done was subpoenaed these documents, subpoenaed these call records, because there would not be a call at 1:51 a.m. showing up on her phone. Now that I'm sitting here thinking about this, there could have possibly been some kind of scheme where like she had a blocked number or a restricted number call her. See, this is the tricky thing with these types of cases. You never know how far they will go. So there is still a way to back out of this. Even though this is a bald-faced lie, there could have still been a call record at that time on that date from a restricted number, even from a spoofed number. And I'm not sure that this is something that I could have proved to be a lie, even with a subpoena. I would have still at least tried it, though. I would have subpoenaed the phone company, and I would have subpoenaed her phone. And if she had deleted that message, or that call entry, then that would have totally destroyed her case, because the judge would have said, "Why did you delete this? This shows that he called it at 1:51." I don't know. She still could have claimed that the phone was lost or destroyed or something like that. This at least gives me a specific date and time to try to nail her down on the lie, though. And it's frustrating to read this now, because this is one of the points that I could have really hit on. But ultimately, you're going to get to that part of the series. We're going to go over how I handled the hearing itself. And I mean, it wasn't a horrible outcome. They extended the protective order for 3 months. The judge admitted she didn't think it was true that anything happened, but I mean, I think I could have done more damage had I, tried to hold her to this specific date and time, because this is the allegation where she's saying I'm going to take her out, which is a bald-faced lie. I was so freaked out, she says. May 20th, by email, he said he will circumvent me any way he has to. Now, this is plausible, but not in the way that she characterizes it. First thing I want to mention is there's no exhibit here, so there's no proof. An email is something that's it's in writing. You should be able to print that out and attach it to this document as an exhibit. Also, no such email was brought up to the court, at least not that I can recall, not that I can remember reviewing. But if I did use the word circumvent, and she puts it in quotation marks, it's plausible that I said something like, if you're not going to allow me to see our son, I'm going to circumvent you by using the legal system to force you to allow me. So this sentence is just like the others. It's implied that I mentioned I was going to circumvent her by hurting her in some way or getting rid of her. But it's a sentence that will still give her a path of retreat, because if a judge calls her out on it and says, why did you say this thing that you said? She can say, well, no, if you look at this email, here is the word circumvent, and he has it in quotation marks, and I just wanted to key in on that word. So it's just that it's that escape route, that they constantly will have an escape route set up to the allegations that they're making. Let's see here. What does she say? Crying and begging him not to leave. Got very angry. Shoved me into the wall, floor, couch. None of that's true. Twisted my arm. That's not true. Later on, when I get to the hearing video, I actually bring up the police reports from the police officers who actually were at the scene, because the police were called twice. Once when she attempted suicide, and once during one of these bogus domestic violence incidences. And in the police report itself, the officer specifically questions about these allegations. And he notes that she didn't have any marks consistent with anything like that. And he also notes, and this is key, he notes specifically that she had trouble focusing on his questions, and that I can't state verbatim, but he was implying that she was lying, that he didn't trust what she was saying, that he didn't find her to be credible, something along those lines. Later on, when we get further along in the series and we get to that actual police report, we can go into it in more detail. Here. This is really bad. When I tried to get him to leave, he shoved me outside. This happened exactly backwards. So she wouldn't let me leave. And when I tried to go outside, she ran outside first with my stuff. So then I remember at this point, whatever items of mine that she had, I just closed the door and tried to lock it so that I could actually get replacement items. So she took my stuff, it was probably like jeans or clothing, shoes, I can't remember what specifically, and ran outside. So my response is, finally I can get dressed and stuff, so close the door and lock it, and then go and I can find some clothing to put it on. As soon as I locked it though, and she probably immediately realized all I was going to do was just find replacement items, she started to scream and make crazy noises, so I just opened the door, let her back in, and the ordeal continued. So I love how this is characterized that she is trying to get me to get out of the home when it's completely backwards. I'm trying to leave and she won't let me. So she says I shoved her outside. She went outside on her own, down 2 steps onto the ground. That's a complete lie. You know what though? If you read that carefully, it doesn't say she fell. So again, it gives her an out. She was shoved outside down 2 steps, but it doesn't say she fell. So if she was called out on that, she could say, Your Honor, I didn't say I fell. I just went down 2 steps. I walked it down the steps. I managed to get an arm in the door before I slammed it on her. He slammed me in the door, quite a few times before he stopped. Now that's a complete lie. That would have shown up real bad when the police came. They would have seen that for sure. Shoot, that could break someone's arm. So another lie. It hurt so much I screamed. That's a lie. She screamed when the door was closed and she realized I had another way of getting items. And when she was, so here she just throws in, just for some icing on the cake, that when she was pregnant in 2006, when she was pregnant, I shoved her. So again, that gives her an out because it doesn't say she was shoved into anything. It doesn't say she was knocked over. It just says she was shoved. That didn't happen, but it gives her an escape route. If she gets called out, you said that he shoved you and, you know, you were this, or this. She could say, no, I didn't say any of that happened. I just said he shoved me. Didn't say I fell. Didn't say I was injured. Blah, blah, blah. So this is hopefully something that resonates with a lot of people who've been falsely accused of domestic violence. I hope that breaking it down to the atomic level and taking these little parts of these accusations apart helped people. I also hope that people having reviewed this can see why my case went all the way to the Supreme Court. And I don't mean my entire case. I mean specifically this issue of accusations of domestic violence used to get a leg up in a custody case, used to get a preferential treatment from the government. So we're talking the confidential address program for victims of domestic violence. That's kind of the context that I'm talking about here. Let's scroll down a little bit. I think in the rest of this application she tells the truth. She's not been arrested, so she says, I don't know if that's true. She admits that I've not been arrested, which is good. Prohibit me from threatening or physically injuring her, which I never would have done anyway. Excluding me from going to her residence, which I never cared to do anyway. She wants temporary custody of the child. This is key. This is the whole point of this entire piece of paper. This one little checkbox here. I love how she asks me to stay away from locations that are confidential. How can a person stay away from a place that they don't know where the place is? So I'm supposed to stay 100 yards away from a confidential location. It's ridiculous. Again, oh no, this makes sense. Stay away from her place of employment. The only time I ever went to her place of employment was to serve her court papers. But apparently I'm now stalking her workplace. Order the adverse party to stay at least 100 yards away from places which I or the minor children frequent regularly. Again, confidential. So she's asking me to stay 100 yards away from all these confidential locations. To not follow me in my car, which I've never done, or have anyone else follow me, which I've never had anyone do. Refrain from making threatening statements, verbal, something texting, or email. This is one of the things that came up all the time in my case. I would constantly say, if I have done anything to threaten her, show the court that I've done it. Text messages, emails, show the court something. She never had one tiny shred of evidence. And in fact, the Supreme Court of Nevada, when they authored the opinion, Falcone v. Secretary of State, they mentioned in that opinion that they couldn't find anything in the record to substantiate that I had done anything to her. So that's frustrating too. So it looks like this is just reiterating. She wants an extended order for protection against domestic violence. Prohibit me from directly or through any agent threatening her. Excluding me from her residence, which I don't know where it is. Granting temporary custody of the child. Again, this is what she wants, really. Order the adverse party to stay 100 yards away from a location that's confidential. Employment, which I never ended up going back to. Once she was served, that was that. That was the end of it. Order the adverse party to stay. Okay, so this is from locations that she goes regularly, which I can't really think of any on the top of my head. And then this is the same thing. Don't follow her in the car and all that stuff. So it looks like here we have the certification under penalty of perjury. So this is back before they had forms with the declarations in them. I talked about that in my previous video. You don't have to get notary stamps and signatures anymore in Nevada. There's now a statute that specifically says that you can do a declaration in lieu of an affidavit, and there is some language, some boilerplate language that you have to include when you do a declaration like that. It says something like, I do hereby declare under penalty of perjury that the foregoing is true and correct. I think that's the boilerplate language. If you include that language anywhere and you sign, that counts in place of an affidavit. So next, let's take a look at my ex's personal case information sheet, which she filed at the same time. I had to file the same thing in my child custody action, though the form I used looked different from this form. This form looks strange, and I haven't seen this form prior to today. I looked over it very carefully to make sure that there wasn't anything confidential in it. It's just a bunch of old addresses from way, way back, so I'm not concerned about any confidentiality issues here. Just like with the form that I filed in my case, this form just helps the court understand whether or not it has jurisdiction over the child. So it discloses the parties, it discloses where they've lived, of course the child's name, and it's just, like I mentioned earlier, it's just used by the court to determine if the court has jurisdiction over the child. So this is relevant. These questions on whether or not she's participated as a witness in child custody proceedings in any other state, this makes me wonder if it's them just trying to make sure that somebody isn't filing for a protective order because they tried previously and it was denied in another state, or if it's one of the exceptions to jurisdiction. I'm not going to, at this point, going into the aftermath, not a whole lot's going to change, actually. Nothing's going to change. My ex prepared the application for order of protection against domestic violence on her own. She used a self-help form, which means she incurred $0 in attorney fees. This specific type of pleading is one of those rare few that does not have a filing fee. So she filed it for free, which means she has incurred $0 in costs. Nothing is going to change on my side. I'm just going to mention at this point in time, I did not know this was filed. The application for order of protection against domestic violence process in Nevada is an ex parte process. So one side could file and then get a temporary order of some kind initially. Later on, my due process rights will be satisfied by allowing me to appear in open court and refute the allegations. All of that's going to be coming soon with the next several parts of this series. So I would encourage everyone to just hang in there for the next video. And of course, as with all my other videos, if you have any questions, comments, feel free to post them down below. And I will see you guys next time.